Straight ahead on Law&Crime Daily. The Sarah Lawrence College sex cult.
Who do you think you are? You think you can just do this to people and just get away with hurting everybody like this? Maritza, you
The final prosecution witness testifies as the government rests its case in the federal trial. Plus, will a man accused of murdering his wife, kids, and family dog be allowed to use the insanity defense?
Any evidence about the defendant's mental health status, diminished capacity, or any evidence of Baker Acts would be irrelevant and would mislead the jury in this particular case.
And the Parkland High School shooting. Could jurors be shown the remains of Marjorie Stoneman Douglas High School? But first, the Olympian attempted murder trial.
They had about 1 second to make a decision, and the decision was he was running up. I was in the house, and I pretty much had to leap and punch him.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. Strong testimony continues in New Jersey as part of the Olympian attempted murder trial. Following the 2-day testimony of shooting victim Lauren Canarak, Robert Goodwin takes the stand, detailing what led up to the shooting. Back in 2019, Goodwin and Canarak were dating and lived together on the property of Michael Barisone. Barisone is charged with 2 counts of attempted murder for shooting Canarak twice in the chest and later firing a shot at Goodwin. Defense attorneys say Barisone feared for his life at the time of the shooting and suffered from mental health issues, even sleeping in his stable leading up to the incident. Ahead of the shooting, Barisone, a one-time Olympian, was training Canarak in dressage riding as she lived on his property. In the days leading up to the shooting, a string of 911 calls were made by both parties. Barisone saying he tried to evict Canarak, and Canarak saying she was being harassed. On the stand, Goodwin told jurors how he reacted after Canarak was shot in the chest.
So after Michael shot Lauren twice, what did you, and you said you were watching him, what did you see him do next?
Well, she turned and ran. And he ran, it looked like he was chasing after her, but then he pointed the gun at me and fired a shot at me.
You didn't get shot,
No.
did you?
No.
After you saw or heard the glass shattering around the window, what did you do next?
I think at that point, I realized what was going on. I realized Lauren was outside. Michael was outside with a gun shooting at us. So, you know, I got up and went to go charge outside.
When you said that you punched him, do you remember which hand you punched him with?
Punched him with my right hand.
What happened after you punched him?
I think I dazed him a little bit. He kind of stood there a little bit. My hand was in complete agony and pain. I think I might have swung at him again. Michael, then turned around, and I didn't know if he was going to chase after Lauren, but as soon as he gave me his back, I took advantage of it.
And what did you do?
Threw him in a chokehold.
And what happened when you put him in the chokehold?
He passed out.
Joining us today is criminal defense attorney Karen Nance and co-host Terry Austin. Karen, Barisone fired at 2 people, one of which seemed to terrorize him and another that attacked him. Do you think the defense could compare Barisone to Kyle Rittenhouse, and would that be convincing?
I think that that's an option that the defense has. They don't have a strong case to begin with because we don't, it's not a whodunit. We know it was Barisone that shot at least he shot Lauren, and he attempted to shoot Robert as well. So the question is, were the facts surrounding this particular incident enough to get him to, in his mind, 1, consider self-defense, and 2, the insanity. And with Kyle Rittenhouse, we look at the circumstances surrounding the Black Lives Matter movement and that particular event that was happening there in Wisconsin. So I think that there could be a comparison in terms of looking at the state of mind of the individual that we have before us. And we have the 911 calls that Mr. Barisone made prior to this incident to the police, indicating that he had some concerns, a lot of concerns about them being on his property. And he also testified, he didn't testify, but there was evidence that he was suffering from some type of depression. So I think that there is a viable option to do that in this case.
Absolutely. Now, Terry, what is your impression of Robert Goodwin as a witness? How do you think the jury is reacting to his testimony?
Well, he was definitely better on direct. But I think as far as the cross-examination, he was extremely evasive and he was arrogant. He was leaning back. It was like pulling teeth. And every single time, defense counsel had to continuously refresh his recollection. He could not get Goodwin to admit to even the simplest things that were actually in text between him and Lauren. He also claimed he didn't know how to shoot a gun. And in fact, he was a Marine. So not credible as far as I'm concerned. He's not doing well in front of the jury.
Yeah, a couple holes in that testimony. We'll see how that continues as the case of New Jersey versus Michael Barisone progresses. Switching gears now to celebrity news, where the producer for the Academy Awards breaks his silence just days after Will Smith slapped comedian Chris Rock on the Oscars stage. The slap aired live last Sunday night during the 94th Annual Academy Awards. As Rock went to present an award, he made a joke about the 1997 movie G.I. Jane, in which actress Demi Moore sports a shaved head. He joked that actress Jada Pinkett Smith, the wife of Will Smith, would appear in the movie's sequel. After that, Smith walked onto the stage and slapped Chris Rock. Though producers cut the audio of the live broadcast, reporters in the room noted Smith yelled at Rock to, quote, "keep my wife's name out your mouth." All this comes after Jada Pinkett Smith revealed to fans that she suffers from alopecia and now struggles to grow hair on her head. Academy Awards producer Will Packer tells Good Morning America Smith was asked to leave the awards but refused. Later, Los Angeles police was on call to arrest the soon-to-be Oscar winner Will Smith.
The LAPD came and needed to talk to Chris. And so they came into my office and they were laying out very clearly what Chris's rights were. And they were saying, this is battery. We will go get him. We are prepared. We're prepared to get him right now. You can press charges. We can arrest him. As they were talking, Chris was, he was being very dismissive of those options. He was like, no, I'm fine. He was like, no, no, no.
In more news out of California, parole is once again denied for a famed murder member of the Charles Manson cult. This week, California's governor blocked parole for 72-year-old Leslie Van Houten, who infamously took part in the Tate LaBianca murders in 1969 when she was just 19 years old. At the time, Van Houten was a follower of Charles Manson, who worked to start a race war in Los Angeles by orchestrating a string of highly publicized murders. Since her conviction, Van Houten has had 21 parole hearings, 5 of which recommended her release. This year, a parole board again recommended her release, but Governor Gavin Newsom blocked the release, saying Van Houten, quote, currently possesses an unreasonable danger to society if released from prison at this time. Still ahead on Law&Crime Daily, years after the deaths of his wife, children, and family dog, a former physical therapist is set to stand trial for their murders. But first, Parkland school shooter Nikolas Cruz will soon be sentenced for the crime. We look ahead to the coming jury selection. Welcome back. Prosecutors say jury members should be allowed inside the Parkland school shooting crime scene as part of shooter Nikolas Cruz's sentencing phase. This just days before jury selection is expected to begin. In October of last year, defendant Nikolas Cruz pled guilty in the Marjorie Stoneman Douglas High School shooting. In February 2018, 17 people were killed and 17 more injured when Cruz opened fire in the high school. The building was sealed off after the shooting, leaving behind visible bloodstains and bullet holes. Prosecutors argue jurors should walk through the school to get a better understanding of the shooting spree. The defense attorneys argue the jurors will already see gruesome video and hear disturbing testimony about the attack. In all, 20 jurors will likely be seated. Jury selection is expected to begin on Monday and last for several weeks. Law&Crime Daily is set to bring you live coverage when the penalty phase begins. Back to break down the long-anticipated Parkland shooter jury selection is criminal defense attorney Karen Nates and Terry Austin. Terry, we saw this in the Brett Hankison trial. Do you think the jurors should be allowed to physically go to the scene of the shooting?
Actually, Brian, I don't think they should be allowed to go there. If I were the judge, I would say no. And the reason is, if they go to the scene, this is a horrific crime. And going to that scene, seeing what happened, where the kids were shot, absolutely is going to affect that jury. And what the judge has to determine, is it more probative or is it more prejudicial? And if it's prejudicial, then they should not go to the scene. And while obviously this was a horrible crime and Nikolas Cruz absolutely should be prosecuted to the fullest extent of the law, I think going to the scene is going to be extremely prejudicial.
Now, Karen, let's talk jury selection. If you were the defense, what kind of questions would you want to ask prospective jurors?
Well, the most important thing is, what is their position on the death penalty? Because those are the two options: life without the possibility of parole or the death penalty. So you want to make sure that the jury, one, is going to be fair, that's going to sit. So in addition to wanting to know what their position is on the death penalty, because they're going to be excluded for cause, meaning that the decision here is, should he be put to death or not. And so that, once we get over that hurdle, the issue is, from the defense perspective, will they be willing to listen to all the evidence that's going to be presented on both sides before making a determination, and making sure that they haven't formed their position ahead of time.
Yeah, but interesting to see how this selection process unravels. It's going to be a very long and I think hard process for both sides. Thank you both. Also in the Sunshine State, a Florida Highway Patrol report says a 13-year-old boy was driving recklessly when he crashed his dirt bike last December while trying to speed away from patrol officers. It happened just one day after Christmas, as Boynton Beach police attempted to pull over Stanley Davis III. According to the report, Davis was going 85 miles an hour when Officer Mark Sohn tried to pull him over. The officer had a history of being involved in deadly vehicle pursuits and was suspended at one time for violating rules and policies during a pursuit. Officials now say he will not face charges in Davis's death. From here, there will be an internal affairs investigation to determine if police department policies were violated. Well-known civil rights attorney Benjamin Crump is representing the boy's family. He claimed Sohn struck and killed Davis and violated policies during the attempted traffic stop. A wrongful death lawsuit was filed on behalf of the Davis family in January. Coming up on Law and Crime Daily, the prosecution wraps up its case in the Sarah Lawrence College cult federal trial. Plus, a quadruple homicide in the shadow of Disney World. We look ahead to the trial of family man and accused murderer Anthony Todt. Welcome back. A Florida judge rules mental health issues will not be allowed in the coming case of Anthony Todt, who's accused of killing his wife, 3 children, and their family dog, not far from Disney World. Federal authorities found Todt's wife, 2 sons, daughter, and the family dog dead at their Celebration, Florida home in early 2020. They were originally there to arrest a physical therapist on unrelated insurance fraud charges. In a jailhouse letter to his father, Todt claimed his wife was to blame for the killings. When Todt was arrested, he said he had taken Benadryl in an attempt to commit suicide. The judge previously ruled to allow one confession from Todt, but exclude another after detectives failed to fully inform him of his Miranda rights. His defense team argued the medication may have had an impact on his capacity to understand what he was saying. At a hearing this week, the assistant state attorney argued evidence about his diminished capacity or mental health would mislead the jury. Todt's defense said they plan to bring up the issue of his mental stability after the deaths. The judge then made his ruling.
I am unaware of any case law that supports the defense's contention that an argument of diminished capacity or suicidal ideations in any way affects the determination of a trier of facts determination as to whether statements are credible or not credible, or what weight to give to those statements. The court finds it to be clear that the issue of diminished capacity is inadmissible in the state of Florida in the guilt phase, and the court is going to grant the state's motion. There is case law that supports that any medications that Mr. Todt was on at the time of his confessions should be considered if they are established by competent evidence.
Jury selection for Todt's trial is set to begin Monday. Law and Crime will bring you gavel-to-gavel coverage as the case unfolds. Criminal defense attorney Karen Nance and co-host Terry Austin join us again as we break down Florida versus Anthony Todt. Terry, the judge's decision to exclude Todt's mental health, we just heard it there, but do you agree, and does that all but destroy the defense's case?
Well, actually, it eviscerates the defense's case. What else is he going to be able to claim? There's no question that he committed the crime. This is not a whodunit. And in fact, there's a confession. Although part of the confession was excluded, some of it has been included. And the part that is included definitely talks about killing his wife and children. This type of defense, the mental capacity, is definitely going to help his case. And if it's out, his case is basically nothing. He's got that confession, and there's no question that anyone else did it. So I think it's going to really hurt his case.
All right, Karen, Terry said it's basically nothing, but I still got to ask the question. So only one of two confessions come in, no mention of mental health issues. What do you think opening statements will focus on then?
Well, we don't have too much to go on at all as from the defense perspective. The only thing is to go back to what his original statement was, which is not really credible, which is his wife killed the children and the dog, committed suicide herself, and tried to drug him with the Benadryl. I don't think it's a very viable argument at all, but that's all he has to go with that I can see. If we can't, the defense can't bring in the insanity or diminished capacity defense.
All right, it's going to be interesting to see what the defense comes up with. Of course, we know what the prosecution is saying in this case, but as we said, the Law&Crime Network will have you covered for gavel-to-gavel coverage as the case comes up. When we come back, will the Sarah Lawrence College cult federal trial soon be handed over to a jury? The prosecution rests its case, but what's next for the defense? That's ahead on Law&Crime Daily. Welcome back to Law&Crime Daily. The government rests its case in the New York trial of accused Sarah Lawrence sex cult leader Lawrence Ray. This after the final prosecution witness was called to the stand, the mother of three of Ray's alleged victims. Ray is facing several federal charges, including tax evasion, racketeering, sex trafficking, and money laundering, among others. He's accused of running a sex cult over the last decade, which he allegedly started out of his daughter's on-campus housing at Sarah Lawrence College in 2010. Jurors have heard from several of Ray's alleged victims, including Claudia Jury, who testified about becoming a sex worker at Ray's suggestion. And Ray is accused of taking the millions of dollars she earned. The jury also heard from three other alleged victims who are all siblings: Santos, Felicia, and Yulitza Rosario. On Friday, their mother took the stand as the government's final witness. Trial exhibits give a glimpse of the strained cause between the siblings and their mother. Law&Crime's Adam Klasfeld is following this case from inside the courtroom and was there on Friday for Maurizia Rosario's testimony.
The government wrapped up its case, and one of the last witnesses to take the stand was Maurizia Rosario. She is the mother of three of the alleged victims in this case. Felicia Rosario, those who've been watching this unfold from the beginning may remember, was Larry Ray's ex-girlfriend and the woman whom he called his wife. She called him her husband. They all gave very harrowing accounts on the witness stand about what their lives were like with Larry Ray. There had been testimony by the mother about not hearing from her children, about Santos being desperate for money, that prosecutors allege he was forced to pay to Larry Ray. And so that was a note to end very powerful testimony on the trial.
Karen, the prosecution ends on jailhouse calls. Do you think this is an ironclad case, or can you see places where reasonable doubt can crack the prosecution's case?
It appears to be an ironclad case. We have these witnesses testifying to this horrendous experience, and we have this older person that basically takes advantage of these young people and used his daughter basically to get the trust of these other individuals that were at the school. And it's just unheard of to have a parent living on campus in the dormitory. So that that is really outrageous. So I think that there has been enough evidence presented beyond a reasonable doubt to convict him of these federal offenses.
Yeah, I won't lie. As a defense attorney, I'm always looking at these cases we cover and say, hey, here's an argument here, here's an argument here. I don't see one here. But Terry, from what we've heard of the defense's cross-examinations, who do you think they'll have testify? Seems they've already want the former lawyer, Glenn Ripa, to testify.
Listen, I agree with both of you. This looks like an ironclad case as far as the prosecution is concerned. But the defense has made a couple of points here. Remember, they had Claudia Drury on the stand for days, and they did get her to admit that she embellished and she fabricated certain details. So I think they're making some small points, but very small. As far as calling Ray's prior counsel to the stand, they're going to have to do that. The defense has already signaled in a memo that they're going to try to use advice of counsel defense, and that when Ray accepted compensation from Drury, that was because he was authorized to do that because it was for Drury's sex work and she poisoned him. None of it, Brian, makes any sense if you ask me. I can't imagine an attorney advising someone that this was acceptable, but they're going to have to call him to the stand. They're going to have to ask him all of those questions, and we'll find out and get to the bottom of it.
Absolutely. Let's figure out how this legal advice went. Well, thank you both. And thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.